With the post-Watergate precedent on the line, let's bring in MS Now Justice and Intel reporter Ken Dilanian, MS Now legal analyst and former law clerk to Sonia Sotomayor, Melissa Murray, and our national security and intel analyst, former FBI assistant special agent in charge, Michael Feinberg. Melissa, your reaction to what we heard from the Attorney General. It would almost seem as though their theory is if you say the quiet part out loud, then it can't possibly be nefarious.
Well, I mean, I appreciate the honesty from him. I mean, just a few days earlier, we had the Attorney General of the United States doing a most extraordinary thing, which is speaking at one of the president's rallies, which, again, might seem to violate the Hatch Act, something that he is charged with enforcing. But again, we know who Todd Blanche is. We've known it. Everyone has known it. The fact that he was confirmed Attorney General is honestly astonishing in my view. I'm still old enough to remember when Zoe Baird and Kimba Wood withdrew their nominations to be Attorney General because they had failed to pay taxes on household help. At times when the law was not clear that had to actually be done. So the fact that Todd Blanche can completely foul up the disclosure of the Epstein files, negotiate a slush fund, and provide the president and his sons and his companies with tax immunity and still be Attorney General truly boggles the mind. But this is the timeline we are in.
Indeed. And Michael, you had Blanche going beyond dismissing hypotheticals about what Trump may or may not ask. He refused to say that he'll act independently. Take a listen.
Can you pledge that the Justice Department will always act independently of the White House?
Well, there's a big difference between saying we will always do our job and investigate any case and act independently of the White House. No, I'm not going to pledge that. And no attorney general should ever pledge that.
So just to illustrate for the audience, because I know I don't have to illustrate it for you, just how unusual that is. Here are his predecessors pledging just that. Just a sample. Take a listen.
I believe that the Justice Department must be independent and must act independently.
These are policies that protect the independence of the department from partisan influence in law enforcement, that strictly regulate communications with the White House. I have grown pretty immune to any kind of pressure other than the pressure to do what I think is the right thing.
In the current environment, the American people have to know that there are places in the government where the rule of law, not politics, holds sway, and where they will be treated fairly based solely on the facts and the even-handed application of the law. The Department of Justice must be that place.
Michael Feinberg, if you are at the FBI, if you are at the DOJ right now and you hear your boss refuse on a Sunday show to commit to independence, what signal does that send to you?
It sends to me that DOJ is no longer an independent arbiter of the rule of law, enforcing statutes and the Constitution without fear or favor, but is rather a just highly credentialed and well-educated political office that belongs to the White House. Independence really is going to come in two forms during any given administration. The first is a guarantee that criminal prosecutions are not going to occur simply because the president dislikes somebody. We know that that is happening in this administration. We know it because Trump himself has told us in numerous Truth Social postings, including one which was originally intended and mistakenly made public because it was supposed to be a private message to Pam Bondi asking why Comey and Letitia James had not yet been prosecuted. The second form of independence is going to be that which guarantees the Justice Department will take criminal wrongdoing by members of the White House seriously. We know that's not going to happen because, as Melissa just pointed out, Todd Blanche himself just committed what seems to be a very clear violation of the Hatch Act. And as far as I know, the Office of Special Counsel, which is supposed to enforce the Hatch Act, is running on a skeleton staff. So I don't have confidence that any sort of independence is going to be granted. And in that, I'm glad Blanche was honest. But I also don't have any confidence in his statement that Trump is not going to ask him to do something unethical. In that, I think he was being fundamentally dishonest.
Ken, I want to hear what you are hearing from inside DOJ about all of this, about the fact that the Attorney General is now hitting the campaign trail, about everything that he said this weekend on the Sunday shows, and about the possibility that we are now at the end of the DOJ framework that has been in place since Watergate.
Well, what people I talk to hope is that it's not the end. It's a temporary suspension, and there's 2.5 more years, and then normalcy will be restored. That may or may not happen. We can only hope that it happens. But, Blanche was answering the straw man question in those interviews when he was saying, like, do you expect me to say no to the president when he asked me to investigate violent crime? That's not the issue here. Presidents have always been able to set broad policy parameters of the Justice Department to tell their Attorney General, I want you to focus more on this and not that. The issue is specific criminal investigations, not just President Trump, but senior White House officials regularly on conference calls with people of the Justice Department. And my own reporting tells me that that's happening all the time. Getting their hands into the middle of individual prosecutorial decisions and decisions not to prosecute and decisions to drop cases. That has never happened before in modern history. It didn't even happen to this extent before Watergate. They have completely distorted the way the Justice Department runs. And a lot of the people I talk to, have their heads down and are hunkered down and trying to ride this thing out. But what we saw when Todd Blanche gave that speech the other day at the DOJ is they've hired hundreds, if not thousands, of loyalists, of people who are only too willing to execute the Todd Blanche orders that come through the White House and not ask questions. And so we're in for a rough ride here over the next few years in terms of what the White House can make the Justice Department do and not do. Alicia.
Melissa, I want you to pick up on the point that Ken is making about his reporting. If you have a president who routinely and publicly, to your point about what the president has been saying on social media, calls for specific prosecutions of specific people, and an attorney general who publicly confirms the president does influence him, what kind of bearing does that have if those cases get to court? I mean, we've talked a lot about selective prosecution, political prosecution, presumption of regularity. Are they actually undercutting their own ability as things move through the legal process?
So, as you know, and as we've discussed before, to present all of the elements that are required to effectively show a selective or vindictive prosecution is indeed a very high bar, but it does not help that the president is actually indicating why he wants certain individuals prosecuted, and that you have an attorney general who makes very clear that he is susceptible to that kind of entreaty. So will it be determinative? Not sure. Can't really say. Depends on everything else. Will it certainly be considered? I think so, yes.
The DOJ currently 0 for 22 in court trying to obtain state voter rolls. Blanche talked about where that fight goes next. Take a listen to that.
So you're going to take this all the way to the Supreme Court, do you anticipate?
We'll see. We'll see what happens. We're trying to work it out with states. Of course. Yes, absolutely. It's a possibility. Election integrity is something that President Trump ran on and the American people elected him. It's something that every American should care about. And so the idea that the Department of Justice is trying to investigate issues around elections to make sure they're fair and make sure they're conducted the right way is not something that we should be running away from. That's something we should be running right towards.
Melissa, where does this specific issue fit into this court's view of executive power?
Well, we're going to find out. And so this is a court that's been very jealously protecting sort of boundaries between state and federal government. And the Elections Clause of the Constitution says very clearly that it is the states that get to set the time, manner, and place of elections, although Congress can, in certain circumstances, override it. The question in these cases is whether Congress and a law that was passed in the 1960s, Title III of the Civil Rights Act of 1960, as well as some other subsequent voting rights laws, would allow for the Attorney General of the United States to direct the states to turn over the voter rolls. Those were laws that were created in the civil rights era for the purpose of ensuring that states weren't preventing people from voting. Obviously, here it's being used in the inverse, ostensibly for the purpose of investigating voter fraud that cannot be substantiated or corroborated. But the question is going to be at the court whether they'll continue to protect that line between the separation between the state's power and the federal government's power, or whether the executive and the president through the Department of Justice has broad, unparalleled power to step in and demand things of the states that have never been demanded or required in the past.
And if they decide, Michael Feinberg, that the executive does have that power, what does that open the door to?
Quite a bit. It would obviously depend on the scope of the ruling and how much it really embraced some of the conservative philosophy that came about as a sort of counter-revolution to the norms that Watergate established. But I'm not confident that any such ruling would actually be narrow in scope. I think it's very important to note that a lot of the conservative philosophy which is motivating this administration, not just the unitary executive theory, some others, was really the result of the Justice Department during the first term of Reagan's administration, when it was sort of in-house think tank / fever swamp for the generation of ideas about how to restore to the presidency what had been ceded to Congress after Nixon. And it's important to note, 2 of the Supreme Court justices worked in that DOJ. John Roberts was a special assistant to the Attorney General and then went to go work for the White House counsel's office. And Samuel Alito held a number of positions under those attorney generals. So I think we're really looking at a wild card as to how the Supreme Court is going to act. And one thing we've seen repeatedly over the past year and a half is that this is a Supreme Court which does not feel itself bound to the holdings of the district courts below it or the circuit courts of appeals. But more importantly and strangely, they also don't feel beholden to the findings of fact. And that is a real shift in terms of how the Supreme Court operates. And I do worry how expansive any such ruling may be.